Welcome to this video on China's 2025 non-compete revolution. We will decode the new MOHRSS guidelines to balance trade secret protection with talent mobility in the Chinese market. This content is brought to you by AllBright Law Offices. The new era is defined by precision. The MOHRSS guidelines target the abuse of non-competes, moving away from blanket bans. Compensation benchmarks have increased, especially for long-term restrictions, and the guidelines serve as a judicial roadmap for stricter enforcement of fairness. Non-compete agreements must protect genuine trade secrets, not general skill or industry knowledge. A trade secret must be non-public, hold commercial value for the firm, and be subject to active, documented confidentiality measures. If these criteria are not met, the interest is not protectable. The guidelines emphasize targeting the key minority. Non-competes are enforceable for senior management and senior technical staff with access to core secrets. For mid-level staff, companies must specifically justify the secret being protected, as blanket bans are increasingly unenforceable. Article 13 introduces a new compensation suggestion. For restrictions over 1 year, non-compete pay should be 50% or more of the employee's average monthly salary. This compensation must never fall below the local minimum wage, which acts as the statutory floor. Article 16 bans salary inclusions. Non-compete compensation must be paid monthly in cash after termination. Claiming it was included in the monthly salary or bonus is no longer a valid defense. Late payment exceeding 3 months will void the employee's obligation. Scope limitations are critical. Business scope must be limited to competing products or businesses. Geographic scope must align with actual business reach, and broad bans require heavy justification. The maximum duration for any restriction remains at 2 years. Regarding violations, liquidated damages are capped and should generally not exceed 5 times the total non-compete compensation paid. If the loss exceeds liquidated damages, the employer can seek full actual loss compensation. Payment of damages does not automatically release the non-compete duty. If an employer unilaterally terminates an active agreement, they must pay a 3-month compensation break fee. Employers must perform an activation assessment upon departure. If the agreement is not needed, notify the employee in writing to avoid activation. To ensure compliance, MNCs should follow a 4-step roadmap, conduct an asset audit of trade secrets, map roles to define key personnel, update contracts to reflect the 50% benchmarks, and implement a mandatory exit protocol with activation assessment. The legal insights in this video are provided by Baokui Guan, partner at AllBright Law Offices. He specializes in cross-border disputes, FDI, and labor compliance, ensuring certainty for global enterprises in China's evolving legal landscape. Thank you for watching. The images used in this video were sourced from Vecteezy. We encourage you to review the full guidelines for comprehensive compliance.